resource location is available. So if you want to go to the site, we can see it. And this is very useful for backward linkage as such. This is the way forward. Identify and upload important judgments by SATs, receipt of important articles and notes for content participation, is scrutinize important articles and then improve contents so that finally we get a different universe in which knowledge exchange is very fast and we are able to deliver quality judgments, we are able to get quality inputs, researchers can come out with a good articles, litigants can feel satisfied, and they will also get to know why a particular judgment has been given. Their satisfaction level will improve. This is what we are targeting at. Sir, time may not permit because all the participants, all the dignitaries are waiting for your guidance. Otherwise, we can show you the live demo where we can see how a search is done. One sample, if you permit, we can show you. Live demo पे जाइए. आप जाइए. एक स्टेट ले लीजिए. वहाँ जाइए ना, कर्नाटक पे जाइए. क्या वो तो कर्नाटका? If you want to search by a state, now right now we are selecting Kerala. And here he has to put. Now you don't want to put anything else, just judgments of Kerala without selecting subject. You select subject, etc. You subject author, then it becomes more accurate. It's data mining sort of thing. And then captcha has to be entered, and then you get the detail. Captcha डालिए. The principal bench of Kerala, without any limitation of subject. Keep it capital. Captcha should be capital. J3. आपका J capital है? हाँ है. Go down. ऊपर कीजिए. आपने J नहीं दिया capital. अब XB से डालिए. Don't select any branch. X पे डालिए ना. अब यही ना करो ना. कैपिटल कीजिए और कैपिटल. हाँ नहीं ये will be there. So this is the way, these are the two judgments they have taken on this particular subject from principal bench on Kerala. So data entry now working day and night, we are working for more and more data entry by selecting the important judgments and inviting articles and notes also. So this is small presentation, we made it. Thank you, sir. You can go by forum. You have to go by forum, we can have another forum. You take it quorum. Okay. It is okay. Okay, thank you.
I request His Lordship, Justice Abhirog, Judge Honorable Supreme Court of India to guide us.
Good evening. Sister Justice Mridula Bhatkar told me that this is going to be informal function. Therefore, I am taking liberty of not taking names because here there are constitutional functionaries, highest state functionaries, the members of the tribunal, not only of Maharashtra, but other 3 states. So I'm taking liberty of not taking their names. But I'm very happy to see judiciary being represented here, highest state functionaries are here, the Advocate General is here. I must thank Sister Justice Bhatkar for inviting me to this function. It is more than 4 years that I have left Bombay High Court, and this gave me opportunity to meet so many old friends, so many acquaintances. I'll start with a lighter note because Mr. Lonkar, who was my friend and colleague in the bar, said something about the fact that I love gossip by the lawyers. I have said it very often about these gossips by the lawyers in different contexts. The first context was when we started VC hearing when I was in Bangalore at that time as Chief Justice of Karnataka High Court. And the lawyers were not used to it. They were sitting at their respective homes because some of them could not reach their offices. And we used to hear the cases, dictate the orders. And this was the experience of all high courts, I suppose, or even Supreme Court, that after the case was over, after the judges dictated order, sometimes we could hear something which is normally said in the corridors of the court by the lawyers. And of course, in Karnataka, I had a privilege, though I could understand spoken Kannada, but I could always plead that I did not understand Kannada. But in one more function, I said something very important about this, that, it is fundamental right of the lawyers to gossip in the corridors. Because if you don't gossip in the corridors, your life will become very dry. And therefore, in one of the functions held in one of the young law students asked me a question. That, sir, you have been a judge almost for 19 and a half years or 20 years. Have you missed anything? So I said, I have missed only one thing, the joke shared by members of the bar in the corridor after the cases are over. Now, coming to Maharashtra Administrative Tribunal, formally the tribunal was constituted in January 1991, but it started functioning in July 1991 in a small premises in New Bombay. And we were lucky in the sense that the chairman was late Justice Chandrasekhar Dharmadhikari. He took initiative, he laid down the procedures, he streamlined. I was comparatively a junior lawyer. I had occasion to appear there only in one case. And at that time, my chamber colleague, Mr. Kishore Malpatak, was the first presenting officer. He was the only presenting officer with the tribunal. And I had wonderful memories of my first appearance because there were few cases on the board. And after the case was over, we were invited by Justice Dharmadhikari to his chamber. And there are other junior lawyers. He explained to us the importance of these administrative tribunals. He explained why there was a constitutional amendment which provided for enacting a law for creating tribunals. Actually, today is the day when I'll be reiterating the importance of having such administrative tribunals. All of us know Article 323A, which enabled legislature to frame a statute, and statute came in 1985, Administrative Tribunal Act. And all of us know that important function of the High Court, in fact, jurisdiction of the High Court under Article 226, dealing with service matters of the state government employees, was taken away from the High Court and was conferred on the tribunal. If you see the provisions of the Act, if you see the objects and reasons of the Act, the idea was to create an expert tribunal, like we have tax tribunals. The members of the tribunal were expected to have intricate knowledge of the service law and the service rules of the government servants. The difficulties faced by the government servants, because legislature also contemplated that there will be large number of cases filed before the tribunal dealing with the orders of transfer. And therefore, there was very innovative provision incorporated, which is on par with other tax tribunals, that administrative member, a state functionary, a distinguished civil servant, or a distinguished state functionary who has wide experience in the administration was made part of the tribunal. And in fact, I think section provides that a division bench cannot be constituted unless there is one administrative member. The idea was to create a forum where the government employees will get justice. They will not be required to go to High Court. They will not be required to spend more for getting pension or getting their retirement benefits or many other injustices which they suffer at the hands of the state. The idea was that most of the cases will be settled at High Court level. In fact, initially, all of us know the development of law. Before L. Chandrakumar came, it was not possible to challenge the orders of tribunal before the High Court and everybody had to go to the apex court. Of course, the thing changed after L. Chandra Kumar's case. High Court started getting flooded with the writ petitions filed by either the state or by the employees challenging the orders of the tribunal. Some of you are aware that some states felt that the tribunals are not workable, therefore tribunals were abolished. My personal view is that it's a absolutely wrong move on the part of the state government. Rather than that, we should have introspected. Even today, we can introspect and find out why the tribunals were not as successful as it was contemplated in 1985. 2 or 3 reasons which I understood with my long experience in judiciary, I'll just share with you. The first reason is the tendency on the part of the state government to challenge each and every order passed by the tribunal before the High Court. I am giving example of tax tribunals. Now, the central government has policies. Not that every order can be challenged before the High Court or before the higher forum. They have policies which matters can be carried to the higher forum. And those policies are abided by. And the central government keeps on improvising on those policies. I personally feel that since very higher state functionaries are here, Advocate General is here, Law Secretary is here, the state must formulate a policy, whether it is really necessary to challenge each and every order passed by the tribunal by filing writ petition in the High Court. Sometimes I get an impression as a judge of the High Court, maybe as a judge of the Supreme Court, that this exercise is done just to get certificate from the higher court that the MAT was right. Therefore, state must examine this matter because ultimate idea was that the disputes must rest here and only in exceptional cases that the disputes must be traditional courts. So perhaps before the higher court will continue, we need to look at this aspect very urgently. The second reason is we are not able to strengthen our tribunals. It is very, Mr. Ronkar referred to a judicial order passed by me as a judge of the Bombay High Court. It is very unfortunate that the constitutional courts are required to pass orders for giving infrastructure to the courts and tribunals. In fact, talking about the Maharashtra Administrative Tribunal or Administrative Tribunal established under the 1985 Act, in fact, state should be very keen on providing far better infrastructure to the tribunal on its own. Of course, today we see this beautiful infrastructure. Mr. Ronkar rightly said, we don't see such infrastructure available with most of the courts and tribunals. So the second area where we are lagging behind is we are not able to provide proper infrastructure to the tribunals and especially the administrative tribunal. Today we are in better premises, but look at what is happening in Aurangabad or what is happening in Nagpur. It is not necessary that it is not sufficient even if you give good infrastructure. You must give good infrastructure to the members of the tribunal. Very eminent civil servants join this tribunal. Retired judges of the High Court, instead of going for greener pastures of arbitration and opinion work, they prefer to work as members of the tribunal, as chairman of the tribunal. The government must acknowledge this fact and ensure that each member of the tribunal is provided with infrastructure, proper housing, proper facilities, basic facilities should be provided to them so that they are able to work properly and they are able to contribute more. But that is where we are lacking. Mr. Ronkar referred to the orders passed by Bombay High Court in PIL. I will not take credit for that. I'll give credit to my Chief Justices who ensured that from 2015, a special bench is constituted dealing with issues of infrastructure of courts and tribunals. And I consider myself to be lucky that I was always part of that bench. So I will give credit to the institution of Bombay High Court, to the Chief Justices of the Bombay High Court. But here I want to add a rider. In Bombay High Court, presiding over that bench, I must have passed orders running into thousands of pages. One of the judgment runs into 200 pages. But since state officials are here, I want to share with them my experience in the state of Karnataka as Chief Justice. In state of Karnataka, I have not seen any such order being passed by the High Court because it is not required to be passed. My experience as a Chief Justice for 2.5 years or 2 years and 4 months was everything which was demanded by the High Court was sanctioned without any query by the state administration. And this is irrespective of the party in power. There are 2 or 3 different parties in 2 or 3 chief ministers when I was there. Irrespective of the chief minister, we were never required to take up the issue on the judicial side. And therefore, if you compare I remember in April 22, the Bar Council of Maharashtra had arranged a conference, state level conference, and I was called upon to address the members of the bar on the kind of infrastructure which is available in state of Karnataka. And that was done deliberately because there are 4 senior cabinet ministers of the state government were to attend that function. And at that time, I pointed out to them that kind of infrastructure which is provided in other states, and we are lagging far behind. And I hope and trust that as the situation changes, perhaps the Chief Justice of Bombay High Court will not be required to constitute such a bench. The state should endeavor to create such a situation that every demand made by the judiciary, every demand made by the tribunal is accepted by the state. Because ultimately, the courts and tribunals function for the benefit of common man. Ultimately, the common man looks upon the courts and tribunals as somebody who will grant them relief, somebody who will protect their rights which are granted by the constitution. And therefore, change of approach on the part of the state government is required. If the state government has a policy of not challenging too many orders passed by the tribunal, if the state government provides proper infrastructure, not only to the tribunal, but also to the members of the tribunal, I am sure that this experiment, which was started in 1985, of providing these service tribunals will be immensely successful. We see that happening in case of some of the tax tribunals. Tax tribunals are doing good job because they have good infrastructure. Now, coming to today's initiative, it is a wonderful initiative. I always believe that the data of all the courts and tribunals must be on public domain, because that gives a lot of transparency to the functioning of the courts and tribunals. Some of you must be aware what revolution National Judicial Data Grid has brought about. National Judicial Data Grid contains data of all courts, all civil and criminal courts across the country, where you can see the order passed today by some court sitting in Meghalaya or Assam. And all data is available there, whether the judge was on leave, how many adjournments were granted, why adjournments were granted, entire data, filing data, pendency data, how many 10 years old cases are pending, how many cases of women litigants are pending, how many cases of senior citizens are pending. Entire data is on National Judicial Data Grid. And I want to emphasize on this. There are leading organizations in our country which are doing research on the basis of that data. Vidhi is one organization. Gokhale Institute in Pune did that exercise about 5 years back. Of course, at that time, the kind of data which is available today on National Judicial Data Grid was not available. But this enables many leading institutions to make a research. They are able to pinpoint where we are going wrong. All those reports are available on website. There are so many reports which point out that where our judiciary is going wrong, why we are not able to dispose of old cases, why we are granting more adjournments. So once the data is on the website, that gives a lot of transparency. Because as member of the judiciary, I have always said on public platform that like any other institution in the world, judiciary is not infallible. There are mistakes which we commit. There are shortcomings in our institution. If we have such data available on our website, it allows us to improve ourselves. And therefore, I welcome this initiative. Now, when we have this kind of a facility available where entire data will be put on the public domain, it is very important that the data has to be accurate and there has to be real-time updation of the data. Because unless we have real-time updation of the data and unless we have very accurate data available, the entire experiment will fail. Because now, slowly we will realize that after this facility start functioning, people from not only Maharashtra but 4 other states will start accessing to the details, the data on the website. In fact, I remember as chairman of the computer committee, we were flooded with emails and letters pointing out that, look, sir, this data entry is incorrect. In a particular civil court in a taluka place, there is a wrong data entry. In fact, there is a very beautiful feature of National Judicial Data Grid. It also indicates how many are cases which are pending, which are not assigned dates. So all undated cases are also available on National Judicial Data Grid. So data accuracy is going to be important, and that is going to be a huge task before the technical staff and other staff members of the tribunal. In fact, this is such a good initiative. After I saw the presentation, I realized that, in fact, there should be one common site for all state administrative tribunals across the country, like National Judicial Data Grid, so that judgments of all the tribunals are available for benefit of each other. And one very good feature I saw on this, there is a link to eSCR. I don't know how many of you have access to eSCR. Now, this eSCR is a new initiative by the Supreme Court. Now we are uploading all our judgments on eSCR, and it's just like other softwares which are available, like Supreme Court cases or AIR. Now we are providing a good search engine, and the judgments are uploaded with head notes. And the head notes are prepared by the law clerks, young law graduates working with the judges, and they are, of course, verified by the research team of the Supreme Court. Now, this eSCR is going to bring about revolution, because a small-time lawyer, a young lawyer who can't afford to pay the subscription of, say, Supreme Court cases, he will have free access to all the important judgments, latest judgments of the Supreme Court. And one more initiative which we can consider, and which is already there, is to have hybrid facility. Justice Bhatkar just now told me that we have hybrid facility. Hybrid facility is very important for all courts and tribunals. Hybrid facility enables the state government officials, somebody is summoned before the court, summoned before the tribunal. A state government official can sit in Mantralaya or his own office, wherever it is there. He may be in Aurangabad, he may be in Nagpur, he may be in district place. He can sit at in his own office and attend to the proceedings, either of the High Court or, in this case, the tribunal. This enables the lawyers to take liberty of addressing the tribunal by sitting at their home or office. You know, somebody is sick, somebody is not able to travel up to the tribunal, or on a rainy day in Bombay, the lawyers are not able to reach. And therefore, it is very important to have a robust hybrid hearing system available in the tribunal. And I am glad that I could see those screens in the courtrooms, that system is very much there. One more suggestion which I want to make. First suggestion is, of course, to create a common website for all administrative tribunals. I'll take up this matter with the Honorable Chief Justice of India. If he takes initiative, that will happen very quickly. The second suggestion which I want to make, which is again recent initiative of the Supreme Court. Now we are trying to ensure that very important judgments of the Supreme Court and very important judgments of the High Court are translated into local language. Because before the tribunal, there will not be only class 1 employees. There will be group D employees coming to the tribunal. Now they must understand why tribunal has decided against them or in their favor. So slowly this initiative will have to be taken up of translating the judgments of the tribunal into the local language. I am dealing with 4 states. Now that facility is already available in Karnataka. There are very cheap softwares available which can be used for this translation. Only thing is the translation is required to be weighted. In fact, Supreme Court has devised a software, AI tool, it's an AI tool known as SUAS. With the permission of the Chief Justice of India, even I can share that SUAS tool so that this initiative of translation can be undertaken by the tribunal. Today we are in such a beautiful place. Justice Bhatkar just now told me that afterwards the tribunal will get permanent premises with area of minimum 18,000. I'm putting it deliberately this way, minimum 18,000 square feet. Because I'm sure if the tribunal is strengthened, by the time government gives us the area, we'll require more area. And I'm sure that after we shift to the regular place, we'll have far better facilities and far modern facilities. I always feel that this is a tribunal for the government employees, and therefore this tribunal should be more modern than the other courts and other tribunals because it's basically a creation of the state government. Before I end, I must make a brief reference to my sister, Justice Mridula Bhatkar. You are fortunate to have a dynamic leader. I know her from her days as Registrar Judicial of the Bombay High Court. She made a suggestion to the Chief Justice, which was a very innovative suggestion, that we need to conduct training workshops of our staff. Not only we need to train them, but we must understand their difficulties. We must give them forum to express their difficulties. And Chief Justice accepted it. I was made the head of the that committee which conducted the workshops, and she went to the extent of devising syllabus for those workshops. And she used to address members of the staff on practically every first and third Saturday. Some of us used to join. And she was the one who was able to establish very close rapport with the members of the staff. I remember she was principal district judge at Kolhapur when our present CJI, Justice Chandrachud, and myself, we were guardian judges of the Kolhapur district. And we had occasion to visit the district court because there was, I think, 5-yearly inspection. And we are amazed to see that Justice Bhatkar had inspired the staff members to work so much. Everybody was so enthusiastic. And only one thing one incident which I remember, when we went there, Justice Bhatkar came out with a very serious grievance. Those were the days when the premises to the court building were adequate. Premises in a court building inadequate. Of course, now we have one of the beautiful courts constructed there. And therefore, a makeshift premises were made available in administrative wing of the collector's office. And there were 7 courts established there. And all 7 courts were occupied by young women judicial officers. And she was at pains to point out to us that, sir, there is a very serious difficulty that for 7 judicial officers, there was one common washroom that also at the end of the corridor, which was a place designated for the prisoners to sit. Prisoners are brought to the court. And she was so serious about it. So Justice Chandrachud said that first thing which we'll do is we'll go to that premises. So we went to the premises. We called PWD engineers. We explained to them that it is very easy to create. In fact, Justice Bhatkar had a plan ready. She showed us that, by making small modifications, we can create washroom and chamber for each courtroom. And then Justice Chandrachud and myself, we told the PWD engineers that we want assurance from you that within 7 days, you will complete the work of creating washrooms for our judicial officers. And if you don't do that, we'll continue to stay here in Kolhapur and we'll tell our Chief Justice that unless this work is done, we are not going to resume our duty. I believe Justice Bhatkar remembers that. Our Chief Justice still remembers this. So she has a humane approach. I'm not going to dwell on this. You must have read her book. But I was touched by something which is very different. I don't know whether she has stopped it. She used to write beautiful articles in, I think, Sunday version of Lok Satta, Saturday. Fortunately, I could get online access to that even at Bangalore and Delhi. A very touching thing which I want to share with you, she wrote a very beautiful article on her driver. I have not seen any member of the judiciary doing that. Writing a beautiful article on her own driver. And I have still preserved that article with me. I hope that she publishes a collection of those articles. So you have a good leader, and I'm sure under her leadership, I think the tribunal will make progress. Here, I was heading the committee for selection of the members of the tribunal. We do the exercise of making selection, but there is a huge delay on the part of the government in clearing those names. Just in a lighter vein, please don't quote me. I am saying it as a citizen of India, that sometimes that delay is more which we see in appointment of High Court judges. In fact, in Karnataka, I had a unique experience. The process was conducted and the appointments came so late, at least 2 members were ultimately selected. Their appointments were approved. By that time, they had taken us some other assignment. So we had to start the process again. So the central government needs to look into this aspect that when the process is conducted, the approval has to be granted within reasonable time. It can't take a period of 1 year. Because if this continues to happen, the senior bureaucrats will be deterred from accepting the post. So that is one area where we have to work, and I'm sure that our young and dynamic Advocate General is hearing all this, and he'll communicate this to proper place. I have exceeded my time by 3 minutes. So before I close, I thank all of you for giving me this opportunity to have brief interaction with you. And it was a great pleasure for me to interact with some of the senior members of the bar whom I have met after a gap of 4 years. So I thank everybody, and I wish great success to this tribunal. Thank you.
Good evening all, honorable dignitaries, distinguished guests, and all the respected participants. On behalf of the Honorable Justice Sri Abdul Rahim, Chairman Kerala Administrative Tribunal, Honorable Justice Sri Budhyal, Chairman Karnataka Administrative Tribunal, Honorable Sri Said Baba, officiating Chairperson West Bengal Administrative Tribunal, and Honorable Justice Mridula Bhatkar Madam, Chairperson Maharashtra Administrative Tribunal, I am here to express the vote of thanks. We are thankful to our chief guest, the Honorable Justice Sri Abhay Og sir, for accepting the invitation and for sparing time from his busy schedule. Sir, your speech was truly inspiring, and it will remain as a guiding force for us. I would like to express sincere thanks to the Honorable Justice Revati Mohite Dere Madam and Honorable Justice Gauri Godse Madam for accepting the invitation and for gracing the occasion. I am thankful to Sri Virendra Saraf sir, Advocate General of Maharashtra, for being with us for today's function. The essence of all beautiful art, all great work is gratitude. I would like to express our gratitude to the Honorable Chief Secretary, Sri Manoj Kumar sir, for sparing his time and to be with us for this beautiful evening. I am thankful to Sri Kishore Rajan Nimbalkar sir, Chairperson MPSC, for the valuable presence. Thank you, sir. I would like to express my gratitude to Mr. Neeraj Dhote, sir, Principal Secretary, Law and Judiciary Department, for accepting our invitation of this useful project of launching of website. I am very grateful to Sri Vivek Fensarkar, sir, Commissioner of Police, Mumbai, for gracing the occasion. I am grateful to Ashwini Bhide, madam, Additional Municipal Commissioner, for her continued support to this tribunal. Thank you, madam. Our special thanks goes to Sri Ghare, Vijay Patil, and Ronak for all the help and guidance they have given throughout the journey from idea of preparation of website till launching of website. Without your contribution, sir, the program might not have been possible. My deep sense of thanks and appreciation goes to all the senior council, president, and members of the bar for attending the function. Thank you all. Thank you. I request all to join us for the high tea. Thank you, sir.